Good morning, everyone. Thank you for joining us today. We're going to get started. And I just want to say thank you for choosing to spend your lunch hour with us today. This is such an important session, and we're so pleased to be joined by our partners, KPMG, today, to be able to walk us through some of the most difficult times that not-for-profits have ever faced and get some of those very complicated questions answered for us today. First of all, we're just going to go through a few housekeeping items. So if you'd like to keep your audio on mute, feel free to keep your camera on as well. This is an interactive session. So if you have any questions, you're able to use the chat feature that is down below. So we've had questions submitted previous to today when you registered, as well as through chat. So Bethan and I will be monitoring that to make sure your questions are brought forward. On the top right-hand corner of your screen, you'll be able to choose your view, speaker versus gallery. So if you want to be able to scroll through and say hi to other people and see who's in the room, or if you just have it on speaker, you'll be able to have the speaker front and center. There will be time for questions and answers, so please make sure you stick around to the end. As well, we're recording this session, so if you don't want to be on camera, and have an issue with that, please just turn your camera off. We do, though, if you've ever presented virtually, it's great when presenters can see the people who are in the audience and know that they're engaged. So we ask if you see something that, or hear something that resonates with you, or it's a great idea, just give a little wave of your hands, because it's always great when the presenters know that you're engaged. As well, we will be having an evaluation that will be sent out with follow-up information. There's lots of resources and things that we will be sharing with you after this. And we ask you please to take the time to fill in the evaluation. It's really important as Leadership Waterloo Region moves forward the next few weeks to try to pull together classes and sessions where we can come together and learn and get through this time. I'm now going to turn it over to Bethan.
Thanks, Diane. This morning, I'm going to run through a couple of what we're calling our virtual convening principles. So Leadership Waterloo Region, like many organizations, had to pivot pretty quickly to be able to continue on and provide our programming in a meaningful way. So it was important for us to be able to pull together some virtual convening principles to guide us how we would approach this unusual situation. First off, no one signed up for this. So no one signed up for sickness or for social distancing, and not for the additional stress that a situation like this puts on our everyday lives. No one signed up for having to facilitate things virtually instead of in person, and not for participating at home and dealing with those day-to-day struggles, and especially not for mastering new technologies. We will focus and remain human-centered. So we're going to prioritize supporting each other as whole human beings, and we're going to prioritize the sharing of resources and making sure that we communicate as clearly as possible, because as we all know, communication is at the core of almost every challenge that we face. We can and will continue our mission virtually. Shared experiences are not really possible for Leadership Waterloo Region in person, given our physical distancing regulations. But we are committed to creating emotionally engaging virtual spaces. And finally, we will remain flexible and adjust to the situation. So no one knows how long we're going to be needing to adapt and continue along this path. And everybody needs to support and understand one another in this unprecedented time. And in times of crisis, we've decided that we're going to lean on our strengths-based leadership of trust, compassion, stability, and hope. Now, I've just given you a fairly high level overview of our virtual convening principles. So if there's anyone on this call that would like this document as a reference for their own work, or to share with someone else that might find this valuable, feel free to just drop me a quick note in the chat, and I'm happy to copy down your information, and I can send that out to you over the next couple of days. So I'm going to turn it back over to Diane, who will introduce our facilitation team today.
Great. Thank you so much. It's my pleasure to be able to introduce our speakers today. We have two folks that have joined us all the way from Calgary, as well as Ben coming from Ottawa. First, there's Jenna Kirk. Jenna is a lawyer with KPMG Law. She's in the business law practice at KPMG Law in Calgary. Jenna has experience advising on a wide range of employment-related matters, including employment contracts and agreements, workplace policies and procedures, wrongful dismissal claims, discrimination, the duty to accommodate, discipline, and termination, work sharing, and supplemental unemployment benefit plans. She has successfully helped employers and employees understand their legal rights and responsibilities under provincial employment standards and human rights legislation. We also have Ben Lynn, manager at KPMG Enterprise Tax, joining us. As I mentioned before, Ben is based out of their Ottawa office. He joined the firm in 2017 and currently serves in the KPMG National Response Team, helping clients navigating through employment relief measures during these uncertain times. Ben has been in the income tax practice for 6 years with experiences in Canadian corporate and personal taxes, as well as tax incentive programs. Last but not least is Sebastian Elawny, a partner at KPMG Law in Calgary. Formerly a member of management at a large international law firm, Sebastian acted as both the National Charities Lead and Calgary Tax Lead, specializing in the outbound international practice. Sebastian brings 12+ years of experience delivering and managing tax-driven commercial transactions, and he's able to work efficiently with KPMG's professional advisors to deliver seamless legal solutions to clients across various industries. I think you'll agree that we're in good hands today. At this time, I'd like to say thank you and turn it over to Ben.
Thank you, Dan. Let me share the screen with everyone. Okay, thank you for joining us. So as a quick introduction for this morning's presentation, I will start with some of the tax-related matters. And then Sebastian is going to discuss some of the legal considerations. And Jenna is going to cover most of the employment relief programs at the end. So as Diane mentioned, we are going to leave some time for a Q&A session at the end of our presentation. So I will begin with a brief mention of the tax-related matters. So for corporations, any filing due date after March 18th is now extended to June 1st. So if you are an incorporated NPO, the same extension applies to filing your T2 and T1044 returns. For charities, if you have any filing requirement for a Form T3010, that's normally due on or after March 18, now extended to December 31st. For GST-HST, any remittance related to February, March, and April can now be deferred to June 30th. In the most recent announcement, the CRA has confirmed that the deadline for business to file the return remain unchanged. Those who are able to should continue to file on time. However, recognizing the difficult times faced by businesses, the CRA will not impose penalties where a return is filed late, provided it's filed on or before June 30th, 2020. For payroll, no extension has been granted on the payroll remittance, so income tax source withholding must be remitted on time for each pay period. For employers covered by Ontario's Workplace Safety and Insurance Board, they will be able to defer payment of the premiums for 6 months. This means that business can defer premium reporting and payments until August 31st. Eligible employers with annual payroll up to $5 million would be exempt from employer health tax on the first 1 million of the total Ontario remuneration in 2020. Eligible employers who are registered charity can claim this exemption even if their payroll exceeds this 5 million threshold. For a 5-month period between April 1st to August 31st, penalties and interest will not apply to Ontario business that miss any filing or remittance deadline and certain provincially administered taxes. This include employer health tax, fuel and gas tax, insurance premium tax, etc. Another point I want to mention is that as many employees are now required to work from home, some of them could be able to deduct certain home office expenses if certain conditions are met. The employer will be required to sign off on a prescribed form to the employee upon filing their personal income tax for this year. Many businesses and organizations are now facing significant financial challenges battling through the current crisis. I want to bring your attention to some of the programs that are available to NPOs. The first program many of you might already be aware of is an interest-free loan of up to $40,000 provided to small businesses and not-for-profit organizations. Repaying the balance of this loan before the end of 2022 will result in a loan forgiveness of 25%, which is up to $10,000. A change announced yesterday has further extended the scope of eligibility to any organizations that can demonstrate they paid between $20,000 to $1.5 million in total payroll in 2019. If you are a union, charitable, religious, or fraternal organization, or any entity owned by such an organization, to qualify, there is additional condition that the organization needs to be a registered T2 or T3010 corporation that generates a portion of its revenue from the sales of goods or services. So currently, to apply for this loan, you need to contact your financial institution directly. If you are hiring post-secondary students and have not been receiving funding from other sources, you might want to look into Magnet Student Workplace Program. This program is available to Canadian businesses or NPO. The government is also making temporary changes to the Canada Summer Jobs Program to allow employer, including NPO, to receive an increased wage subsidy. This could include the subsidy up to 100% of the provincial minimum hourly wage for each employee in this program. Department of Finance recently announced that the government intends to introduce a program that helps small businesses on their rental expenses. How this program works? The program will provide loans or forgivable loans to commercial property owners, who in turn will lower or forego the rent of small businesses for the months of April, May, or June. There will be more details coming out regarding to this rent assistance program. So far, what I covered is not a complete list of financing or government funding program. Feel free to reach out to us if you have any questions or need any assistance pathfinding access to government funding. With that, I will turn it over to my colleague, Sebastian.
Thanks, Ben. That was awesome. So we'll be discussing some legal considerations. You can go ahead and go to the next slide. But so when I found out yesterday that we were going to be doing this this presentation over video, I'm going to admit that I had a pretty massive panic attack. I hadn't changed my T-shirt in a couple of days, and I've been working on my couch. and it brought to mind this little article that Jenna sent me. It made me laugh because you like to think that lawyers are always these well-dressed and well-groomed people. So one of the judges in the Weston Bar Association, I don't know where that is, somewhere in the U.S. I'm guessing, wrote this letter, and it got posted on the Weston Bar Association website. It said, "We've seen many lawyers in casual shirts and blouses with no concern for ill grooming, in bedrooms with master bed in background, etc. One male lawyer appeared shirtless, and one female attorney appeared still in bed, still under the covers." And so, the commentary from earlier about how, nobody signed up for this. Nobody knows how to manage any of this, right? So thought I'd lead with that, and we'll talk now really quickly about a number of different things. We're going to go through director obligations, because I think director liability is a question, and sort of what it is you need to do to manage your operations. We're going to talk about meetings, because I think meetings are one of the major areas of difficulty for board meetings and for member meetings, AGMs. And then we're going to go through a very quick run through on contracts. We could go through contracts for hours, but we have limited time here today. So before we start on the discussion of directors and officers, there's a bit of there's sometimes a little bit of a challenge in understanding the way corporate designation works as compared to tax designation. So we're going to be using the term not-for-profit corporation throughout this legal discussion. And so not-for-profit corporation is the entity that was formed, the corporate entity. So in Alberta, we have societies under the Societies Act. In Ontario, you can be a corporation formed under the OCA. And federally, you can be a corporation formed under the Federal Not-for-Profit Corporations Act. That is the entity. You then have a tax designation through the Income Tax Act. So if you're a not-for-profit, you're a not-for-profit under Section 149. And the proper designation for that is a non-profit organization under 149 of the Act. And if you're a charity, you fall under registered charity under 149.1 of the Tax Act. So the point is, when I discuss not-for-profits, this all applies equally to a charity as it does for a non-profit organization. So as a general rule, when we talk about director liability, directors won't be personally liable for the liabilities of the organization and its potential failure, which I don't like to talk about, but provided that they meet their duty of care and haven't acted fraudulently. So there can be additional specific statutory liability that comes up under various legislation. For example, most people on this call will be aware of the fact that there's director liability if you fail to deduct and remit source deductions or GST under the relevant acts. So what are your obligations as a director? You have two of them. As a general rule, you have a fiduciary duty, which means you have to act honestly and in good faith with a view to the best interests of the organization. You shouldn't be getting into things that are in a conflict, that put you in a conflict position with the best interests of the organization. The second thing is you need to have you need to realize a certain standard of care. That standard is not perfection, but you need to exercise the care, diligence, and skill that a reasonably prudent person would exercise in the same circumstances. We love to use that phrase in law, the reasonably prudent person. I can tell you this, the reasonably prudent person is significantly more prudent than anyone I know. So I think it's actually a higher standard than people think. But I'm going to quickly run through a number of the considerations you need to look into. There are dozens more, but I would say minimum things to meet the standard. First, you need to understand your duties as a board. As a board, most of your governance comes from your bylaws. So you need to look at those. You need to understand what you can and can't do. And we will talk more about bylaws. You need to keep doing your duty as a board. I'm assuming most people on this call have already had a board meeting, because most boards meet monthly, some meet quarterly, some meet semi-annually. But you need to keep having your meetings. As part of your bylaw review, you're going to want to know about whether you can have electronic meetings or phone meetings, and we'll talk about that in a bit. You need to document your decisions, probably now more than ever, so that you can track the timelines of the decisions you've made as a response to the events that are happening. And it'll allow you to allocate responsibilities amongst members of your team, and so that you'll know who's responsible for what. So you need to be aware of government actions. There's a ton of government programs, restrictions, and filing deadlines. Ben talked about some of the tax deadlines, but there are also some corporate deadlines that are available to you. I will say that on this one, the fact that you are on this call is a perfect example of the things you need to do. Signing up for law firm and accounting shop websites, or for their email outs. That's the kind of thing you need to do to be aware of things, because there's simply too much information coming out at one time for any one person to be reasonably prudent with regards to keeping up with all of it and understanding all of it. But under the under corporate legislation, you still have to file your corporate returns. So under the OCA, there's been some relief, and so that deadline aligns ultimately with the tax return filing. So the dates described by Ben are the relevant dates. Under the Federal Not-for-Profit Corporations Act, you typically have 60 days from your anniversary date, which is the anniversary of your formation date. They have provided an extension to September 30th if your anniversary date is between Feb 1 and June 30th. So the one thing that I found when I was looking through some of the interesting pieces of value available in Ontario is the Office of the Public Guardian and Trustee for the Province of Ontario announced on March 30th, 2019, that for charities and that have restricted purpose funds, they actually, in certain circumstances, which, by the way, if you need them, are going to be some pretty dire circumstances, can encroach upon their restricted purpose funds, their designated funds, to cover operational expenses and contractual obligations. So if you're interested in relying on that, you should find that order, and you should look at it, because it sets out the requirements. It has a number of requirements, and it tells you the things you need to do in order to comply. But at the outset, it's not even worth looking at if you're not going to be doing it as a means of last resort, and B, you have to be in danger of closing. So you need to review your contractual obligations, including your timelines to use funds from grants. I know that most charities are pretty on top of their timelines, because I know it comes up at most of the board meetings I attend. But that's a key issue. You may want to get on the horn with government bodies and see if they're willing to extend those timelines, or what kind of relief they're considering for the charities, because obviously they fund a lot of charities. You want to get an understanding of your financial situation. You want to develop a strategy in case the emergency lasts for 2, 4, 6, 12 months, and how you're going to maneuver that. Comment that I always like is hope is not a strategy. You need alternative plans in case this thing stretches out longer than you originally thought. Once you have a strategy, you can go ahead and address your employee issues. Jenna's going to talk to you about this, but the failure to remunerate employees or remit withholdings, source deductions on their behalf, obviously creates director liability. And the last one I'm going to mention, and then, like I said, there's many more, is that you should consider all of your policies and make sure that they make sense in light of the current state of the emergency. If you don't have policies, we're talking about like workplace safety policies, travel policies, just to make sure that everybody is aware. There's communication strategies you may want to look into as well. So next we'll go to meetings, and for the purpose of the meetings discussion, especially for federally incorporated corporations, you really do need to review your bylaws, because they generally do. Bylaws generally operate to restrict your governing legislation. They do at times expand on it, but it's usually a restriction. You're looking for methods. The things you're looking for are methods of holding and attending board meetings, methods of holding and attending AGMs, methods of amending your bylaws by director resolution, that may be an option, methods of absentee or proxy voting in the event that someone cannot be in attendance, and notice requirements notice requirements for your meetings and quorum requirements for your meetings. You need to be on top of all this to make sure that whatever you're doing is compliant. So the reason this is more applicable to the federal not-for-profit corporations is that they don't have the same level of relief available to them as has been announced in Ontario. I have to admit, as I was looking through this stuff, I was pretty jealous of the Ontario relief because it's pretty practical. So if you're incorporated under the OCA, you're going to really like some of the relief that's available. You may not have to spend as much time with your bylaws. So the relief orders were introduced by Emergency Order Reg 10720, so that's probably worth looking at. I think there have been some articles written about that reg order in Ontario, so you can have a look at that. But these measures generally operate to override your bylaws during the emergency. So typically you have statute, then you have bylaws which restrict the statute, but now you got this emergency order that comes in and says, you know what? We're replacing the statute, and that statute, and for this emergency period, for as long as it's in place, this overrides your bylaws. So when we talk about board meetings, and again, Beth had mentioned at the beginning that nobody signed up for this. You know who really didn't sign up for this? Your bylaws did not sign up for this. So I'll use the term virtual meeting because all the legislation has funny language that I don't particularly like. But virtual meeting for me, for the purpose of this conversation, is going to describe meetings that take place by phone, by Skype, by Teams, by Zoom. That covers all of it. For the purpose of government language, they like to use funny language like telephonic and electronic and whatever. But electronic communications for them are fine as long as they provide for a simultaneous electronic communication method. And so that'll be our virtual meeting language. And then so under the emergency regs, basically Ontario corporations are allowed to hold all their meetings virtually. They can do both their director meetings and their AGMs virtually. Whereas under the Federal Act, you don't really have any relief. So you need to have a look at your bylaws to see if they restrict the general rule. And the general rule that actually applies to both of them is that you are allowed to hold meetings electronically, meetings of the board electronically. And so if you are a federally registered corporation and your bylaws do not allow you to do a virtual meeting, what you could do practically is have the call, have your board meeting, discuss everything you want to do, and then you can turn around, check again that your bylaws will let you do written resolutions, but most of them do. So check that that they do, and if they do, you can go ahead and reduce that meeting to writing, and identify all the resolutions that the board agreed to. And the way that becomes effective is all the board members have to sign that resolution. Now, when it comes to your AGM, some of the stuff gets a little more difficult because while you do still have the ability under the federal legislation and the provincial legislation to do written resolutions, the only way, again, that a written resolution is going to be binding and acceptable is if it's signed by all of the members. So if you've got 2,000 members, and we all have experience where we have very few members showing up to these board meetings, these AGMs, you would have to find a way to get every single one of those people to sign. So it's not really practical. So you kind of have two choices. You can defer your AGM or you can hold it at the scheduled time. So again, Ontario gave some great relief here. The general rule is that your AGM has to be held within 15 months of your last AGM. That's under both acts. The Federal Act actually has some additional language that says, and also it's got to be within 6 months of your financial year end. So it's the shorter of the two. Federal not-for-profits have no emergency relief. So they basically have, the only option they have is to apply to Corporations Canada to extend the time for calling an AGM, unless something comes out. And I would think that as this goes on, there would be a possibility of that. But Reg 10720 for Ontario corporations allows corporations to just simply defer their AGM to a date that is not more than 90 days after the end of the emergency, if their emergency had to take place during the emergency. And they went ahead and they extended that by an additional 30 days if your AGM was supposed to take place in the month immediately following the end of the emergency. And a policy reason for that obviously is that the emergency may end fairly quickly, and then those organizations won't have the time to get their AGMs organized and planned. But if you want to hold an AGM during the emergency, which is, I think it's a pretty reasonable option, you like to continue to operate your organization as much as possible as those times are normal. The only practical solution that I see, and I've considered a number of the different options, and there are other options, they're just not very practical, is to call a virtual meeting. So like I said, Reg 10720 applies to override the OCA, override your bylaws with the temporary OCA language. And so you can actually hold all your meetings, all your AGMs electronically. Under the Federal Act, subsection 159(4) provides that if the bylaws do not state otherwise, any person entitled to attend a meeting of the members may participate by telephone or electronic means if the corporation makes that means available. So there's another section, which is 159 sub 5, that actually really conceptualizes the idea of virtual meetings, but it actually says that they're only available if your bylaws specifically allow for it. So that's not a very helpful provision, because if your bylaws allowed for it, you'd already be able to do it. So going back to the 159(4), the key point is that their argument is that if you are holding a meeting at your office or at someone's home, then that's fine. You can make that meeting available for the attendance of anyone who is entitled to attend, which would include all of your other board members and all of your members. From my standpoint, I wonder if you can get there by me saying I want to hold the meeting at my house. We put it out to everybody. I'm at my house. Is it really a virtual meeting? To the extent you're worried that it takes 2 people to have a meeting, maybe you could just bring a second person over, sit 6 feet apart, and then everybody else can dial in. At the end of the day, your real issue is that there are a ton of considerations you need to work out if you want to run a virtual meeting. You got to find a platform that's big enough to handle your members, the number of people you expect to attend. But there's lots that can handle that, but how do you track the names of the members? How do you allow people to vote? How do you chair the meeting? How do you give people the right to nominate a director from the floor? How do you control the whole flow of communication? So I think there's probably a lot of software out there that's been developed to help this, and if there isn't, somebody should be getting on it pretty quickly. But I think the practice that you really want to consider is do some dry runs, maybe do a few dry runs. I think it'll take a lot more prep to do this than any other AGM you've ever run. And then as a last resort, the Federal Act permits directors to make changes to the bylaws, and then the members can approve it at the immediately following AGM. I have some suggestions as to the ways I would want to go about doing that to minimize your risk of that not being a valid approach. But the point is, the option is there, that the directors could do some kind of an emergency decision, and the members you could make it the first order of business at your AGM, and your members could approve it. So lastly, and I know I'm running over, so I'll be really quick about this, contracts. So we all know you have your key contracts. Jenna's going to talk about the employee contracts a little bit. Obviously your lease agreements, your insurance contracts, your lender contracts, goods and services contracts, events contracts. I know that events contracts have been which is a goods and services contract, but I know a lot of charities and not-for-profits have been really stuck with their events contracts where they've paid for something, or their members or interested parties have paid them for something. If there's a contract in place, you obviously need to look through all those provisions in the contracts. The key clauses you're looking for are force majeure clauses, which I feel as though people have been beaten to death over. All lawyers love to talk about force majeure, even though it doesn't apply very often. Damage clauses, covenants, events of default, and you always need to understand your notice requirements in the event of a breached covenant or the occurrence of an event of default. I will do my lawyerly duty and talk really quickly about force majeure clauses, just because they actually finally do apply to some organizations. So force majeure clause is going to define the type of event that that needs to occur before you can invoke that provision. The words you're looking for are pandemic and government shutdown. And you know, it's nice when the language includes something like or other similar events. And you know, you might find some things in there that actually have a lower standard. So then it goes in and it talks about the threshold. All force majeure clauses are going to talk about what it needs to do to your operations. Does it make it impractical? Does it make it difficult? Does it make it impossible? Obviously, the lower the threshold, the easier it is to rely on. And then finally, it'll define methods of dealing. So it kind of gives you a way to move forward. It tells you what your notice requirements are, tells you what steps you need to take, tells you who you need to email, who needs to be copied, whether you need to include a plan for maintaining service standards and delivery of service. So it helps you avoid the straight out termination of the contract. So again, just I'm going to quickly run through these. Covenants are your promises to the other party going forward, or their promises to you. Breaches of covenants usually result in events of default. You want to look at your damages clauses because they may create liability for the defaulting party, which could result in compensation to the other party. If they're that's often for professional fees of trying to execute on the contract, including lawyers and accountants. But then there can also be liquidated damages, which goes like one step further, which is that they're coming after you for the losses which actually result from your breach of contract or your termination of contract. And then I just want to quickly touch on some of those contract types that we talked about. You should know that your landlords and your insurance providers, they've been through this before. I'll make an Alberta reference. They've been to this rodeo before. Landlords have force majeure clauses, and insurance providers have force majeure clauses, and they usually operate to make sure that you, as the renter or as the insured, don't have coverage in the event of a force majeure event. There's a couple of different levels under leases. One of them is that there's a force majeure clause. It says that, you know, you're relieved of all your obligations, blah, 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 except for you still have to pay. So it makes it a fairly useless force majeure clause. And then your other contracts are going to have a lot better chance, but they're less, you know, depending on how far away you get from truly commercial contracts, they're less likely to have a force majeure clause. With respect to lenders and landlords and service contracts, you want to get ahead of the problem early by communicating with them as quickly as possible, because you're going to want to start negotiating a solution to the problem. And one of the things I've learned since I've been at KPMG is that it would be highly prudent to have a business continuity plan in place before you go in and talk to any lender. And so with that, I will turn it over to Jenna to teach us all about all the great stuff going on under the emergency relief employment programs. You're on mute, Jenna.
Yeah, I know. I'm going to go through this fairly quickly because Sebastian fit a lot into much more than 10 minutes. So if we move on to the first slide. So I'm going to go through this really quickly because most people have already done this. So what I normally discuss with employers when we're looking at stuff is to do a strategic workforce assessment to determine who your core individuals are. Not that you're going to fire everybody else, but just because it makes some of your other decisions a little bit easier if you know who the people are who you absolutely need to be working and to continue business as usual, not as usual. Remote working, I think most people where that has been an option have already looked at that. We can definitely assist with remote working policies if you need policies, as well as performance monitoring programs, because you want to make sure that while the people are at home working, they're actually working efficiently and effectively. And just to make sure you keep in regular contact with those people. There's a lot of people who are feeling very isolated right now. And, you know, even just having these video chats is really helpful for a lot of those people to see a face when they don't normally see a face. Another thing to look at is just reducing hours. And if we move on to the next slide, One of the ways that we like to do that right now, especially, is under the work share program. So normally, if you reduce somebody's hours and therefore reduce their wages, you run the risk of a constructive dismissal claim. So what WorkShare does is it allows you to prevent layoffs. So you're not laying individuals off. What you're doing is sharing the leftover work between the people that you have and all of your employees who are in a WorkShare unit. So a WorkShare unit is comprised of people who do substantially the same type of work. Once you set up those WorkShare units, all of your employees actually sign on to a contract and agree to be part of this WorkShare unit. So from an employment law standpoint, that's great for us because it prevents some of those constructive dismissal claims you would otherwise see. So they've agreed to this program. You can run it between 6 weeks, and they've extended it due to COVID up to 19 months. Hopefully that is not necessary. What we've been doing right now is preparing most of these applications as 6-week applications. Because of how fast things are changing, you don't want to be locked into a program where another program would be more beneficial. And when we first started doing these programs, it was before the Canada Emergency Wage Subsidy came out, and we weren't sure, you know, what benefits programs there were going to be, because a number of them were suggested and announced by the government, and then they didn't end up going through with them. So we put a lot of people on these work share programs and then learned about what we call the CEWS, the CEWS, and then we found out that they do work together. So you can use the wage or the work share program and the wage subsidy together. What we've been doing in that case, oh, we're going to skip on to the next slide. What we've been doing in that case is we generally recommend work share where you have individuals who are over that $58,700 threshold, because what you can do is you can reduce the amount of money that you're required to pay for them while still getting the maximum benefit of the wage subsidy. So I will move on to the next slide. Thanks, Ben. Reducing business costs. So where necessary, doing temporary layoffs with the Canadian Emergency Wage Subsidy, which I will talk about in a minute in more detail. You're able to do a layoff with pay. So typically when you lay somebody off, it's because you can't afford to pay them. In this case, you can do a layoff with pay and use WorkShare to get your employees some money as well. One of the questions I always get is, we don't do layoffs. This isn't something that we do. It's not something that's contemplated in any of our policies or any of our contracts. Like, isn't this illegal? And I get that a lot, actually, and it's not illegal. You can definitely lay off employees. Like I said, you just run a risk of constructive dismissal claims. In Ontario, the temporary layoff period is a maximum of 35 weeks, and any more than that, it becomes considered a termination. And at that point, you have to give severance. It's different in every province. So if you do have individuals across the country in different provinces, you definitely want to look into what the restrictions are on that. I know in Alberta, it was 60 days. It got extended to 120 days, but there's certain areas like BC where they're a lot more restrictive. If we move on to the next slide. So if you have laid somebody off, you can actually top them up by registering a policy, so your company policy with Service Canada, and you're able to top up their EI benefits if they're on EI with this program. And essentially what you do, though, by submitting your policy to Service Canada is you create a binding contract between your organization and Service Canada agreeing to do these top-ups. So I always recommend that you have legal review them before you submit them, because you don't want to be creating a contract and not be fulfilling it. When you register a supplemental unemployment benefit plan, what it allows you to do is top up your employees on EI without grinding down the amount of EI they would receive. So normally if you just give them an additional couple $100 a week, it will reduce the amount of EI they're eligible for. So if you've registered your policy, they can actually keep the full amount of both, which is a great option. Can we move on to the next slide? And as a last resort, terminations. I've been told in a lot of presentations recently not to even talk about terminations, but in some cases it is necessary. And so if you're going to do a termination, you really want to pull up the contracts that you have with that individual and see what the provisions are. So if you've got somebody who's on a fixed term contract, you might actually be required to pay out the balance of that fixed term You might have fixed notice periods within those contracts, depending on the jurisdiction you're in. You might have other employment standards requirements. So make sure that this is something that you know going into the terminations. As well, if you're going to do that, always get a signed release. So I'm always happy to have those discussions with you and talk to you about how to best approach some of these situations. We can move on to the next slide. So the Canon Emergency Response Benefit, I think everybody's heard about this. This is a program where the government will give people who are without income, they give you $2,000 every 4 weeks. So it's equivalent to $500 a week. They changed it on Wednesday morning. They allow you now to earn up to $1,000 before taxes and still be qualified to get the CERB. So if that applies to any of your individuals who may have received up to $1,000 between the period of March 15th to April 11th, that was the first qualifying period, they can go back and retroactively apply and receive this. They have to be Canadian residents, at least 15 years old, and are under the $1,000 employment income. And this is done through their MyCRA account. And there are specific days based on their month of birth when they can apply for this. And that's all online on Service Canada's website. Moving on to the temporary wage subsidy. So there was a lot of confusion when this first came out, and then it was followed by the Canada Emergency Wage Subsidy. A lot of people thought that this one disappeared, but it didn't. So the temporary wage subsidy is the one where you take 10% of the remuneration paid for your employees, and you just withhold it from the remittances that you pay. I think Sebastian has a couple of comments on this, but it does apply to nonprofit organizations as well as charities. I don't know if Sebastian, if you wanted to jump in there and talk about that at all, or we can move on to the next slide. Or he's muted.
I am talking to myself, apparently. Yeah. So, sorry, when it comes to work sharing?
The wage subsidy.
Oh, sorry. When it comes to the wage subsidy, I apologize. I was just checking something out. When it comes to the wage subsidy, there's a qualifying revenue formula that is applicable to charities, as well as a separate formula for not-for-profits. They're pretty similar though. So the legislation that came out on Saturday basically gives us the
sorry, Sebastian, I'm just gonna stop you. We're doing the temporary wage subsidy,
okay.
not the emergency one yet.
I was a little confused because I was like, wait a minute, we haven't gotten there yet, and I don't typically advise on the temporary ones. So, all right, go ahead.
Okay, Ben, that's okay. We can move forward. So I'll pull you in on this one in a second then. So the Canada Emergency Wage Subsidy, this is the one that everybody's excited about. This is the 75% of your employees' wages up to a maximum of $847 per week. It does apply to NPOs and registered charities. You have to show a gross revenue drop of at least 15% for March. So that was initially announced as 30%. They've reduced that to 15% and 30% for April or May. And it's compared either to the month over month from 2019 to 2020 for those periods of time, or you can elect to use the January and February average of this year. There are calculations which are not the most straightforward calculations, but it does include most forms of revenue, excluding revenues from non-arm's length persons. And you can choose whether or not to include revenue from government sources as part of the calculation. This covers all existing employees, anybody you bring back from a layoff, anybody you rehire, as well as new hires. So there's no restriction on that. I know that it was announced as your ability to bring back people who you've laid off, but it does apply to your entire workforce. There's no maximum for how much you can apply for. It's just the weekly maximum per employee. And currently it covers the period, it covers the period from March 15th to June 6th. So it covers wages paid between that period of time. The way the legislation came out on Saturday, it does give them the ability to extend it to the end of September. And most of us who have spent hours and hours and hours talking about this and looking at this would agree that it's definitely going to be extended past that June 6th period. And so what it says is that they will cover up to 75% of those wages, and an employer must make their best effort to top up the employee's salary for the rest of that amount. And so that's what I was talking about earlier with work shares. If you have individuals who are making $100,000, they're only covering $847 per week. So you're still on the hook for the rest of that amount. So you can look at other programs to kind of work with this in order to bring down your total amount needing to be paid to employees as well. If you have individuals who you've laid off and they're laid off with pay, so they're getting this wage subsidy, but they're not actually doing any work for you, the government will also cover 100% of your EI and CPP remittance amounts. So Sebastian, sorry, do you want to talk about this one?
Yeah, sure. And you have it up on the screen right now where you talk about the fact that for NPOs and charities, it includes most forms of revenue. So there is some slightly different wording in the two acts, or sorry, in the two subclauses that deal with this. But I think, you know, it's an interesting thing that they actually have allowed charities and not-for-profits to exclude funding received from government sources. You know, Jenna and I have had, you know, quite a number of calls with charities and not-for-profits where we hear that that once you exclude government sources, you know, some of these organizations may have, you know, several $100,000 worth of government-sourced revenues, government-sourced funding, and that they don't expect those to go down. In fact, even with all the other relief coming out, they may expect it to go up. But if you exclude that and you look at your revenues, they may only have a few $100 in March of last year down to $50 this year. And theoretically, that falls within the black letter of the legislation. As you end up getting into this, this more of this policy, how do you feel about should you qualify, shouldn't you qualify type of question? And so the answer and it's funny because it also it's a knife that cuts two ways. So one, would you be laying people off if you didn't qualify for this subsidy? That's one way to look at it. But then you look at all the charities out there and all the not-for-profits who exist to relieve poverty. Well, this is going to be the busiest time ever. So you're going to be hiring people to join you because you need more resources to deliver because there are more people in need. So that does not fit squarely within the policy reasons of the legislation, but it's got to work out better for everybody in the long run. So it's just an interesting mismatch that comes from this language. So that's all I've got on that.
Awesome. So we'll move on to the next slide.
Sure.
So this is done through the CRA My Business account. So what the government said was if you don't have that up and running yet, you should definitely go and get it set up, as well as your direct deposit. What they're looking at is having these approved 5 days after you request, and money in your account 2 days after if you set up the direct deposit. You can use the wage subsidy and the emergency wage subsidy and the temporary wage subsidy together, but the temporary wage subsidy just reduces the amount that you get on the Canada emergency wage subsidy. So it's just sometimes easier to use the Canada emergency wage subsidy, as well as individuals who are still getting the CERB amounts, they're not eligible for STUs. So if you've got somebody who now you're deciding to bring back and you're going to back pay them, you can actually back pay them and they can repay their Canada Emergency Response Benefit amount, and then go on to the STUs and get their $847 a week. You can move on to the next slide. Yay. Now I'll open it up to questions.
Fantastic. Thank you so much. I have some questions that have come in through the chat, and I just want to make sure I can get to those here. So I have a question that says, many organizations are struggling because of this crisis. Some may not survive. Is it then unreasonable for a director to support obtaining a CEBA loan if an organization is struggling financially? What is reasonable?
It's good. I guess that one is probably on me. It's a good question. The emergency relief loans are specifically there to help save your business, and you don't suffer personal director liability in respect of an inability to repay a loan, particularly one that's been introduced as a relief measure by the government. So I would actually flip the response a little bit and say, it's your director obligation, if you are in financial trouble, to make the application for the loan and to take the money if you qualify. That's what's in your best interest. That's what's in the best interest of the organization.
Fantastic. Thank you, Sebastian. We have Penelope from Newfoundland asking us, I would like further clarification of the requirement to have all members actually sign resolutions. FYI, she's not in Ontario.
Yeah, Penelope and I were communicating a little bit briefly, but it's I don't know what their organization is organized under, but I've looked at the legislation in BC, in Alberta, in Manitoba, in Saskatchewan, Ontario, obviously, and the federal stuff, and they're all the same. Written resolutions for the purposes of members is almost always going to be a unanimous resolution, but you should check your local governing act to see what it says. And what all members means is exactly that. Every person who is listed on your member register needs to sign. And that's why it's that's why it's really a non-option, from a practicality standpoint.
Thank you. Keenan, I'm not sure if your question was answered. I saw you typed it and then Sebastian kind of hit on it. But he asked, to exclude government revenue seems very strange. Does it really mean if 90% of our revenue is from government and 10% from fundraising and donations, that if we all lost only 7%, we would still qualify?
Yeah, Jenna, do you want to do it, or you want me to do it?
Go for it.
Okay. Yeah, it's a pretty clear-cut concept. You include all. You have a choice. You can treat it as though you include all of your government revenues, your government subsidies and revenues, and as well as your donations and your membership fees and all of that. Or if that calculation doesn't work to your benefit, you can exclude it. They haven't set a threshold on percentages, so there's no risk of you being offside the drafting of the legislation under the black letter of the legislation.
That said, this will likely continue for another couple months past what it's currently set out as, and so you can't flip-flop on what you decide to do. So once you decide to go one way, you're kind of stuck with that kind of calculation throughout. So it's good to just look at your forecasting for if at all possible.
I mean, it's easy to figure out. It's like our government funding is not going anywhere, but definitely our fundraising and events revenue is down. I think it's at this point more of a moral question I'm struggling with.
Well, that's right, and that's exactly what I was saying, right?
Okay,
is that you have this ethical dilemma. You're like, wait a minute, I certainly don't want to be someone who is taking money away from somebody else who actually is like struggling and need it. But it depends. Like, that's why I kind of turned the question, because the answer is, if you're not going to be laying people off because you're generally fine, then you're okay. And so one answer I can give you, Keenan, is that there's an overarching policy here, and there's a couple of different things at play. The overarching policy is how is Canada going to look when we come out of all of these emergency shutdowns? What is in the best interest of the country? And what is in the best interest of the country is that we keep people on salary, on staff, so that when we open up the doors, we are closer to being able to hit full throttle as quickly as possible. So the government has made a decision that they are willing to pay this amount for employers to keep people on staff to allow that to happen. And I guess if you take it one step further and you go, okay, what happens if I terminate them? Well, they go on the CERB. And so now you're actually really talking about a price difference that's very small on a per person basis to have them employed versus to have them unemployed. So to keep employers and have them closer to be ready to come out of the gates running. So there's a lot of little nuances to the policy argument on the whole thing. And so I would say that if it allows you to keep people, then you should feel like pretty good about your decision. That is a good ethical line.
Just one other thing to note too, it does say within the legislation that if you use this program, the government has the ability to make that public. So they can do public lists of individual or of organizations that have used this program. And what I've seen that used for in other pieces of legislation, the immigration legislation also has that, and what they use it for is essentially a public shaming list of individuals who have misused or like have abused the program. And so it's just a caution to be aware of if you, if you don't want your name publicly out there that you guys were thriving at this point in time and still use the program. That is a consideration for sure.
I have another question from Donna Marie. Please explain the EI and CPP 100% subsidy.
So it's just, as I said, if you have laid off people and they're laid off with pay, so you're still paying them at least the 75% that the government's covering, hopefully the full amount if you're able to do so. The government will cover 100% of EI and CPP payments. So you have to pay all of this up front. So under the Canadian Emergency Wage Subsidy, you are paying those employees and then you apply for essentially a reimbursement of the money that you've paid out. And the way the calculation works is for those individuals, you get paid back the EI and CPP contributions. And the reason for that is because otherwise you would have laid these individuals off without pay, and you wouldn't have that requirement to pay that CPP and EI. So what they're doing is they're literally fully covering those individuals who have been laid off and you've brought them back now with pay. They're doing that so that you are encouraged to bring them back and put them back on payroll, as opposed to terminating them or having them laid off. For the people that are still working for you, you still have the requirement to cover their CPP and EI contributions.
Fantastic, thank you. Ruth Taylor's asking, do you need to prove a drop in revenue to apply for the wage subsidy?
Sorry, do we know if that's the temporary wage subsidy? Because I think that's the question.
I don't know if Ruth would like to clarify.
Yes, I think I can jump in. Yeah. I think that question is related to the temporary wage subsidy, and you don't need to prove a drop in revenue to apply for that.
Fantastic. So I have a question here from Dan Brown. He said there's some really complicated questions about the CEWS. Given that charities have very irregular incomes, some grant might come in a given month. Do they think these rules will change again? Trick question.
I mean, it's interesting, right?
Yeah.
Like, yes and no, right? The legislation is drafted. It's like, so you have certain things that are hard coded, and they got to actually go to like legislature and pass a new law if they want to change it. And so they made a decision. They actually are well informed on the charity side of this. There have been enough submissions made to them that they made a conscious decision to exclude these government revenues, these government subsidies, as an option. And so, I mean, there's always risks, but you're applying based on a point in time application with point in time rules, and they can't retroactively come back and have a problem with you qualifying under a certain set of rules at a certain time. So the key question is, do you want to qualify on a cash basis? So that you're tracking it on a month by month basis. Because I think when it comes to some of these grants, I'm not really sure how. I'm not an accountant, so I'm about to get myself in big trouble going beyond my skill set. But I think that you get into some questions as to how you report that if you get a big grant from the government, and how that gets measured for accrual purposes. So I think that ultimately. Yeah, Jenna's looking at me going, well, okay, you're just fumbling now because you don't know how to say this. But ultimately, I know that.
I was going to say, ask if Ben had any comments to make.
Yeah. Yes, I do. Yeah, actually, Sebastian, I'm amazed that you can extend it one slide to a 20 minutes presentation. That's big difference between lawyer and accountant. We focus on details, and you guys focus on bigger picture. Yeah, so talking about this one, I think, well done. Yes, Yeah, I think talking about this one, everyone, if you are NPO or you know, in an NPO entity, legal entity, that position situation, you need to be careful if you use this election about remove the government funding from your revenue calculation, because you do need to talk with your accountant to determine is that revenue is in the nature of a government funding or not. Because I've heard about some of the you know, nonprofit organization, they have actually some sales that with end users or the purchaser is from the government division, but would that be considered government funding or not? You need to really provide all the fact pattern to your accountant and to make the decision on that.
Thank you, Ben. Krista asks, any idea when we'll be able to apply for the wage subsidy? The new
Soon?
Yeah, we had a call with finance. I guess earlier this week. We had a couple of them, and one of them was that that was their wording. So Jenna's right. You know, we should expect it soon. Soon and shortly are the two words we keep hearing. We're in week 3 of the original 3 to 6 week timeline. So I think that all signs still point towards them being within that 3 to 6 week time frame. So we're 1 to 3 weeks away from probably this going live.
Fantastic. I still have a few more questions here.
Sure.
George is asking, how much leeway will there be for NFPs and charities in terms of the best effort to top up employee salaries with the 75% wage subsidy? So for many NFPs, any additional funds will need to be used to support the community and keep the organization afloat long enough to keep making an impact.
You can go, Jenna.
I was gonna say, you're still able to run your business, and so you don't have to put your business under to top up these people. I think what that's really trying to prevent, because there's no direct guidelines right now on what that means, but I think that what that's trying to prevent is from having your top level individuals receiving bonuses and things like that, or receiving their full salary and not having everybody else equally receiving money right now. This isn't supposed to be used as a time where you can take advantage of your employees, and I think that's really where they're going with a lot of this stuff. There are definitely some organizations out there that are using this as an opportunity to kind of, weed out some of their individuals who they don't necessarily want to have continue to go with them, and to try and do that using reduced severance pays and all sorts of things. So I think the government is really just trying to protect individuals in saying that. And I mean, there's really no guidance, but you got to be careful with what you do with your money going forward, because we don't think this is an if you get audited, this is a when you get audited. They're going to look back and see what you did with the money and kind of assess you on that. And like I said, there's that ability for them to put you on any type of public list that they want to when you sign on to this. So I'd be very careful if you have the ability to pay your employees and you don't. And we also have the feeling that if you choose not to top them up, you're probably more likely to be audited or assessed on these applications.
Yeah, I mean, the only thing I would say, and a lot of that is really great policy stuff, but the only thing I would say is that when this first came out, there was all of this, you must make your best efforts, right? Every day on TV, you heard it from Trudeau, and you heard it, it came out in the guidance. And then as we went forward, Trudeau's language got softer. Well, you need to try. And now, we have legislation that doesn't say anything. It actually doesn't talk about 25%. So again, until you have law and you have guidance which got softer along the way. The law does not say anything about a requirement to pay 25%. Now, do I agree with Jenna? 100% I do, that if you're paying out bonuses and partners are walking away with lots of money and however you want to call it, and you're not, you've cut your employees to the minimum just so that they're getting the 847, then yeah, I think that's probably a sign of a bad actor, and they'll look at all the facts.
Just a couple more questions here. Oh, sorry, I've lost it on here. We all have one that came in earlier asking if there's any government funding available for community cultural events that will need to be postponed or canceled.
Yeah, my take is that I don't know of anything federally, and I think after that you got to look provincially. I haven't seen anything quite to that specific level, but whatever province you're in, you would really want to. You really need to. I mean, it's as simple as a Google search pretty often to see if something will come up, because you know we lawyers and accountants, we love to like write and teach everybody else about everything we know to try to act like we're experts. So.
And it is just another add-on is there is always options that you can reach out to the donors and see if you could, instead of refund them the money, see if you can, you know, find a way that to issue a donation receipt on top of that, just to save your cash flow.
Yeah, that's a great idea, Ben. That's often donors will have that change of heart.
Mm-hmm.
And I have one here that is, if a not-for-profit organization purchases their staffing services from another larger organization, would the larger organization be the one to make the applications, if eligible, on behalf of the NPO, or would they do that themselves?
I guess the first question is who is going to be considered eligible entity. So you have to have certain, first you have to hire people, incur the employment cost to, you know, to be benefit from this subsidy. And the second is anyone is going to claim, if you do have the people on payroll, you always have to meet the criteria of the sales decline for the threshold. So the only, you know, flexibility, as Jenna and Sebastian explained, is that you have, as NPO registered charity, you can elect to exclude certain government funding out of your revenue calculation.
So yeah, and I just want to add to that. If you don't have employees, then there's nothing to do, right? The wage subsidy is to subsidize payments you made to your employees. You have nobody to lay off. You have nobody to terminate. So it's not even on your behalf. You don't even have that. You don't have that as an option. They, as an organization, the person that you're getting those services from, they're an employer. You're clearly going to stop paying them for those services, or you're going to have to reduce your payments. So they're probably going to be able to qualify because their business has gone into decline. But if you don't have employees, this program is not for you.
Thank you so much. I think we've covered everyone's questions. Is there any questions I've missed? I'll just give you a second to reply in the chat. And just a reminder that we will be following up after the session. We will be sending out the recording, and as well as some resource materials for you as well. Okay, so here, I have another one from Penelope. She says, some groups are seeing the loan as a possible opportunity for a $10,000 grant. So borrow 40K, pay it back in time and keep the 10. Individual banks are the approval point, but government pays the interest. Where are the controls other than shaming?
Yeah, I think that's the funding that I actually covered in my presentation. I don't take it as a, you know, it's unethical to take that 10,000 forgivable loan so as an advantage. I don't think so. I think that's the purpose of the funding to some extent, that if you can pay it back within a certain period of time, not only interest free, but also there will be 25% of the loan repayment, you don't need to pay it back. So I think that's what how the program works. But again, another thing that you need to consult with your financial institution is the eligibility of your institution or organization. Would you be qualified?
Yeah, and so an interesting thing is because I've heard some notice now that this is going to be structured as like a credit line for people. So it'd be like a $40,000 credit line. So it's an interesting thing, and I think a lot of people are going to miss it because look, it is prudent for everybody to take it. If you qualify, you should take it because you need the backup resources in the event that something goes wrong. That is what a prudent director and a prudent organization would do. But in order to qualify for the actual 10,000, and there's no legislation, I'm just talking really practically here. In order to get a 25% discounted repayment, you must have drawn down on that credit line. So if you get a credit line and you don't use anything, well, you haven't taken on any debt, and therefore you don't get any forgiveness. So I'm waiting to see what they do around that, because I think there'll be a lot of people who will draw it, use it as backup. And so maybe that's where your ethical question comes in. Should you be drawing down on this credit line just to make sure that you get a $10,000 forgiveness when you ultimately don't end up needing it? And I don't know if anything's going to come down the pipes on that, but there's no ethical dilemma behind taking a credit line. There's an ethical dilemma behind pulling it out just to get a $10,000 discount.
Yep. And another related, the eligibility, Sebastian just reminded me is, I look at one of the Bank of Montreal, the eligibility of that loan is actually you have to attest upfront that this loan is going to be only used for your for covering your operating cost. So which means in the nature of line of credit, you can't use it to make a capital purchase.
Yeah, but you can use it to replace other debt. So you can replace higher interest debt. I believe so, right, Ben? Or
yeah, I think this one's meant to be to support this business to cover their operating expense, such as rent, or even including your day-to-day office running expenses.
Right, but like, is there not an argument that by reducing your ongoing interest payments, that you are creating some additional cash flow for operations? Right, you're reducing burdens. I don't know. Maybe it's just too small because of interest, but I didn't think it was clearly excluded from my conversations with. Well, nobody seems to know for sure yet how that's going to play out, but that might be a real question.
To the bank.
Yeah, to BDC, or to your actual lender.
Excellent. Well, I'd like to say thank you so much, Sebastian, Jenna, and I'd like to thank Rob Connell from our Waterloo office, who is actually a participant in Leadership Waterloo Regions Class of 20. Rob, thank you for helping us pull this together. You've given a sense of power, because now and there's some release there. So let's keep in touch. If anybody has any questions, it's saying, am I muted?
No, you're okay, Diane.
Okay, I just got a note saying I was muted. And any questions, please reach out. I also want to make sure you know about our upcoming sessions. We're running 2 of these a week. This week we didn't run 2 because of Easter Monday. Beth, and if I could get you to move the slide over. Our next one is on Tuesday, and that is with Cormac Russell, who's joining us from Ireland. And we're talking about planning the resurgence and asset-based community development perspective on COVID-19. So we'll have lots of learning there about partnerships and about how we can prepare to get through this. And then Kevin O'Reilly will be joining us to talk about I Can See Clearly Now, from mental illness to brain health. So how to keep positive brain health during all of this, and some real tools we can use for ourselves and for our teams to help us get through this difficult time. Again, I want to thank everyone for your time, and please follow up if you have questions, if you want to reach out, even if you just want to ask people, how are you handling this situation? We're happy to connect at any time. Thank you very much.